Thank you, and good evening, everybody. Many of you were here last week. I recognize faces, yes. So thank you so much for coming back this week, and I'll just do a quick reminder. Next Tuesday will be the final session of Inside the Courts for this year. Judge Diana Tennis will be speaking about divorce court, okay? A lot of good, which Judge Latimore spoke about divorce court a few years ago on Inside the Courts as well. At least I think he did. But today, she's not going to be speaking about divorce court. Judge Latimore is going to be talking to us about something called unified family court, which she will define for us. A little reminder for you of those who haven't met. Who's ever seen Judge Latimore talk before? Anybody? Anna, I know you have. Yeah, okay. I'll remind you a little bit about Judge Latimore. I can't tell you everything that she's accomplished. It's actually embarrassing to her. We'd be here for about 3.5 hours. So let me just touch on a few of the highlights. She's been a judge since 2006, so she's one of the most senior judges that we have here, despite her very young age. She has a Bachelor of Science degree from Duke University, okay? So please don't talk about basketball. We all know the Gators won last night, and some of us are very
Gator, so let's talk about basketball. Hey,
she did go to the University of Florida Law School, so she amended her ways a little later in life. Judge Latimore has served in almost every division: felony, criminal, juvenile delinquency, domestic violence, currently in unified problem-solving court. Two of her more recent recognitions, she's got dozens and dozens and dozens, but in 2023, she was recognized by receiving the Justice Peggy Quince Judicial Excellence Award. She's a Hall of Fame member of the Paul C. Perkins Bar Association, which is a bar association or bar organization devoted to promoting the advancement of African Americans in the legal profession. Very active in that organization. Judge Latimore is the current chair and founding member of a judicial statewide wellness committee. Takes up a lot of her time doing that. Annually, she hosts one of the greatest events we do here in the Ninth Circuit. Annually, she hosts the Ninth Circuit National Adoption Day. Fills up the entire big jury room downstairs. Sometimes she does it over at the juvenile courthouse, but creating a day-long celebration of forever families, and she's one of her favorite things to do, I know that. Judge Latimore is recognized statewide. I mean, she's called all the time from people in Tallahassee, fancy politicians, Jacksonville, Tampa, Miami, recognized as an expert in dependency, juvenile dependency, problem-solving court, and family courts. She's got at least a gazillion, perhaps more, professional activities that I will not name all of them here. But most important to me, at least, is Judge Latimore is one of my favorite people on the entire planet, and I'm delighted that she's going to be speaking to us tonight. Can you help me welcome Judge Latimore, please?
That was such a kind and gracious introduction, but Bob and I have gone back a long ways, even though he told how old I am. But other than that, we have been very good friends and worked closely together for many, many years. And I'm just honored that he let me come and speak at Inside the Courts again. I have had a chance to do that one time before domestic violence. I think I had a chance to speak at one time. And so those are, areas of the law that are really near and dear to my heart. And this one really has taken first place. And so I am happy to come and speak with you all about our Unified Problem-Solving Court Division and the programs that we have here in the Ninth Judicial Circuit. And so before I get started, how many of you are familiar with problem-solving courts? If you raise your hand, let me know who I'm talking to. Oh, great. Nobody knows. Okay. So you won't know if I tell you anything wrong, right? It's always good. All right. So great. I'm glad you're here, and I'm glad you're interested in learning more about problem-solving courts, because they are magnificent, and they really have made a difference in our judicial response to cases that come before the criminal division as well as our juvenile dependency division. And for those of you who may not be familiar with juvenile dependency, I don't know if you've had a chance to have someone speak to you about that. That is near and dear to my heart, only because as soon as I got out of law school, I took a job with a law firm here in Orange County. That's how I ended up living here, and I've been here ever since, Love Orlando. I was with a firm who had cases with juvenile dependency over in the juvenile courthouse. And so the shareholder or the leading partner took me to court one day, and we had a dependency case. I was a brand new associate, wet behind the ears. She had somewhere else to go, and she just left me there. And I was like, what do I do now? And unfortunately, our client got arrested. It wasn't my fault, y'all. It really wasn't. But But I learned more. That's how I got my foot in the door when it comes to juvenile dependency, and I've loved doing juvenile dependency ever since. But just to explain to you briefly, juvenile dependency is when the Department of Children and Families removes children from their parents due to abuse, abandonment, or neglect. Thus my connection with National Adoption Day, the other end, because I love being a part of having those children be adopted into forever families. And so that's the best day at the courthouse, and if you're ever around, please stop by and see the joy. So back to problem-solving courts. We're going to talk about it a little bit and see if I can explain to you what problem-solving courts are really about. And so what it really focuses on is just having a specialized docket for certain types of cases and the way in which we approach those cases and try to find a resolution to them. So most times when people come to the courthouse, I would say a good number of individuals, or a great percentage of those individuals, are coming to the court to have a problem solved. For example, landlord-tenant issue. I was evicted, or my landlord is about to evict me, so I'm coming to court to see if I can get a resolution to that. Maybe if the judge will let me pay some monies, or will address what I believe the landlord's not doing correct. I want to resolve or correct that problem. Other instances may be in which you have a traffic ticket. And so I have a traffic ticket. Usually I get a traffic ticket, that's a problem for me, okay? So particularly how much it costs to pay for those traffic tickets these days. And so oftentimes you'll come to the court to go to the clerk's office and maybe pay that traffic ticket off, or you may want to challenge it. You have an opportunity in some instances to challenge your traffic ticket, and so you get to go before a traffic court hearing officer to try to resolve that problem. There are many different instances. We talked about family law, issues with marriages or divorces, issues with child custody. I'm having a problem getting visitation. I want to come before the judge and resolve that problem. So we do a lot of problem solving in our courts. That's kind of part of what the judges will do. We're doing it by constraint of the law, of course. We're following the law and what it allows us to do, but often wanting to help find solution to problems that people are experiencing when they come to court. Typically, that's not how it feels when somebody is arrested for a crime. Now, that's a real problem, all right? And now they're dealing with the problem, and oftentimes it's the problem that they're facing is whether or not they're going to get convicted, whether they're going to go to jail, whether or not they're going to be placed on probation, or possibly see themselves in prison. So that's a really big problem for them if that occurs, and can affect their families or their loved ones or individuals who are related to them. But we now have another way in which we are addressing and helping to resolve the problems that come before us in lower level felony offenses as well as misdemeanor cases or traffic cases. And if you give me a moment, I hope you'll be able to understand how this is really making a difference in how we are processing our case and how we reach a resolution that we believe brings us with a better outcome, a longer outcome in the sense that that individual, that defendant, is less likely to reoffend, and therefore we're making the public safer and we're lowering the rate of recidivism. And so as I indicated, we're dealing with specialized dockets for persons and parents who need treatment. And so we're dealing with these cases, and I'll get more specific as we go on, particularly handling cases, lower level felony offenses or misdemeanor offenses for individuals who have mental health disorders, individuals who have substance use disorders, or individuals who have experienced some type of trauma or a combination of two or more of those circumstances. And what we're doing is trying to get to the root of the problem, which is some of these disorders that led them to commit criminal behavior. And we're also going to talk about it in the context of juvenile dependency, where the underlying issue for a parent, which led them to abuse, abandonment, or neglect of their child, is substance use disorder, mental health disorders, or trauma, or some other circumstances that's kept them from being the best parent that they can be. And so we usually utilize, and one of the important things is that we utilize a non-adversarial approach. I'll highlight that even more because that's one of the best parts of these programs that I really enjoy. And we tend to approach it by assisting them to receive the therapy and the treatment that they need, that they did not have an opportunity to receive otherwise or could not afford otherwise, as well as giving them an opportunity to have a different type of resolution to their case other than possible incarceration in the cases in which they are pending before the court. And so we're looking to hopefully make this a better, more productive individual in our society, as well as make our public feel or be a lot safer, because the recidivism rate is much greater for those who participate in problem-solving courts than it does for those who are not. And this picture, or this slide right here, shows you a map of Florida, and these are all the problem-solving courts that are in Florida. And you'll see here that we have 50 adult drug courts, 33 adult mental health courts, 33 early childhood courts, which is in dependency, as well as we also have 33 veteran courts, 14 juvenile drug courts, 13 dependency drug courts, 4 DUI courts, and 1 juvenile mental health court. Understand, that was as of December of 2024, and we are growing in regards to the number of problem-solving courts that we have around the state. So that number may even be different today in April. Additionally, there are other types of problem-solving courts that may not be inclined to fall under what the state has designated as a problem-solving court. For example, homeless court or homelessness court. We have those around the state as well, which helps individuals to receive services if they no longer have a stable home, to assist them with services that they may need until they're able to obtain a stable and sound living arrangement. And so we encourage these. These are very much found to be throughout the country and even around the world in some places to be very effective in the resolution of our cases. So how about that one? Our key components of problem-solving courts is first is that there's ongoing judicial interaction. In the Ninth Judicial Circuit, there's one judge that handles all of the problem-solving courts that we have in Orange and Osceola County. That's me. I don't know who made that decision, y'all, but no, I really volunteered for it. I love it, and I wanted to be there. But what that means, just to give you an idea, is that I handle all of the problem-solving courts, the adult drug courts, the mental health court, veterans treatment court, early childhood court, and dependency drug court, all in Orange County. And I also handle the ones that we have in Osceola County. So I'm doing what they really used to call a circuit judge. I go around the circuit for all the different courts that I may have at the different courthouses. And I ask them, because back in the day, the judges used to ride a horse around the circuit. Remember that? So I asked my chief judge, can I get a horse? I'd love to have a horse, okay? But she wasn't going for that. So with that, I take my little car and drive with the gasoline. So with that, I am handling all of the cases that are in both Orange and Osceola County. I'm going to focus on Orange County since we're here for Orange County inside the courts with you. But basically what I'm handling is a bi-weekly status for all of the participants, particularly early on. They can move into a phase where they've been there and they're improving and they're progressing to where we have them on a monthly docket. What's the difference about that? Typically, when you're in a criminal case, how frequently does the defendant go to court? How many times? Once, maybe. If they have a arraignment and then they have to go to court maybe to see the judge for pretrial conference, and then they might have a plea or a trial, and then it's pretty much over, right? Okay. And otherwise, in other types of cases, even when someone is in probation, they would not go to a court on a regular basis once they have been brought before the court to handle that case. Whereas if they're in our programs, and we'll talk about that, we're going to have bi-weekly or monthly case reviews and status hearings for our participants. That means they get to see me a lot, all right? And I get to see them a lot to see how they're progressing, see what matters we need to address, as well as to let them know how they are advancing, improving in the court. We also have coordinated strategy for immediate responses for our participants, and what that means, and as we go along, is that once we find that our participant is doing well in the program, we have what we call incentives to kind of reward them for how they are doing and how they're progressing. And then other times when they're not doing so well, we have responses to that. But the best thing that we've learned is that immediate response works best. Kind of like raising your little puppy, trying to teach them how to be trained. You don't want to have them maybe make an accident on the floor, and then 3 weeks later you come back and say, bad dog. They're not going to learn that way, right? What we want is an immediate response to individuals. And so that works well in these type courses and the type of treatment that we're offering them also. So I'm going to talk to you about the different types of courts that we have. As I mentioned them to you, I want to give you a little bit more explanation of actually how they work. And actually, before I do that, I think my button, I skipped a couple of slides, so I'm going to go back if you don't mind, because I think there's some other things I want to highlight with you all, okay? All right, yes, the most important thing is the multidisciplinary team that we work with, okay? So when our participants are enrolled in our programs, they're going to start working with a multidisciplinary team that actually has hands-on wraparound services for those individuals. So remember, we're talking about individuals who have substance use disorders, mental health disorders, experience trauma, or have some other types of circumstances that they really are challenged to be successful and productive individuals in our courts or in our society. And so with that, they're not just going to see a judge. They're not just going to be dealing with their defense attorney. Our multidisciplinary team is composed of several individuals, the judge being a key partner in that, but really relying on the team to work with that participant outside of the court. And what that would entail is potentially, and we'll go by this one by one, is a substance abuse treatment provider, a mental health treatment provider, or someone who can address trauma, since those are the key disorders that we're dealing with. So they would be a part of the team. We also have case managers who are part of the teams and other individuals. What's important is that we are working in partnership, and they are working in partnership with community providers. Everyone is working together, and the best part about it is that it's non-adversarial. And so they do not spend a lot of time arguing or having conflict with each other. They're a team working together to reach the best solution and the best recommendations for that participant to be successful. So they're working together to find solutions, as opposed to your typical cases you might see on TV, like Law and Order, where they're often constantly in conflict or fighting against each other. That's not the way it's done here. We even have the state attorney on this team. State attorney and defense attorneys are a part of this team, working together for the sake of finding solutions for the participants. We also are providing those services I mentioned to you in regards to treatment for the areas that they need help with. Going back, okay. I'm a little slow, y'all. Don't worry about it. Okay. All right, so I mentioned to you that we have ongoing interaction with the judge, our case status and review hearings, and also our coordinated responses. But in addition to that, we have continuous service, meaning that the participants are going to participate in our program, but when they stop and being in our program, that doesn't mean we just cut them off. They may be successful in working in our program, and they're doing well in their substance abuse treatment. They're doing well with following up on their mental health treatment, taking their medication, making their appointments, and even dealing with other health type of services that they may need. We realize that often individuals don't come with just one situation or one issue in which they need help with. And so with that, they get a continuum of services. If they need some assistance with being in contact with a primary care physician, then the team is going to help them do that. And even when they leave the program, they can always reach back to the team to ask for further assistance or referral. We always tell our graduates, don't forget, we're your team, we'll always be your team. If you call that number, somebody's going to answer who's willing to help you. And so there's a continuum of services from being a part of the program. We have regular and frequent alcohol and drug testing for the point of ensuring, one, that they're not using drugs, two, to find out if they are using drugs, what is that drug and how do we appropriately address or develop a treatment plan for them. And we continue even after they've stopped using because we want to make sure that they can maintain abstinence. And we can't do that without them having drug testing on a regular basis. Successful completion of the program, this is the good news. The successful completion of their program can result in the dismissal of their case by the state. And so they participated in the program. They've got a brand new start on life because no longer are they dependent on drugs. They also have their mental health issues. They've gotten their mental health issues where they recognize what those mental health issues might be and how they should regularly take their medication, as well as the case that they came on has now been thrown out by the state. There's 2 tracks that they can go. That's one, which is called diversion, and if they successfully complete the program, the case is dismissed. The second track is called post-plea. In some cases, because of the circumstances or the history of the participant, their criminal history may factor into the state saying, no, we can't do diversion, but we can do a post-plea track, which means the defendant is going to enter a plea first, and then they successfully complete the program. The case, while they're in the program, they'll be on probation with the condition that they do this program successfully. And if they do so, then at the end of the program, when they graduate, they'll be able to walk out the door without being adjudicated a felon, so they're not convicted, and they also have early termination of their probation and will not have to remain on probation for the remainder of the term. And so that's the advantage, in addition to, again, becoming a positive and productive member of society, having dealt with the issues that brought them to the criminal justice system or juvenile dependency. So let's talk about our courts. Is it me or my nails? I don't know. There we go. Let's try nails. These are the courts that we have in our circuit at this time. The first one being the Adult Drug Court Program, in which we're treating eligible individuals who have a substance use disorder. That is really the identifying factor in which they might be eligible for our program. And they are now involved in the criminal justice system, which means they committed a crime, and they have that crime charged against them by the state. The second program is the mental health court. That individual has participated in criminal activity, and we're trying to increase public safety as well as lower the rate of recidivism of their participation in crime. And by doing that, we're going to address their serious mental illness, have them recognize and appreciate that they have a mental illness, have them understand what type of treatment and medication may be appropriate to deal or to treat that mental illness, and be able to continue to live a positive life even though they may have that diagnosis. Last but not least is our Veterans Treatment Court, and it's actually the last one that we're going to talk about as far as the criminal track. Veterans Treatment Court. And this is for our members of the military, our servicemen and women who have actually been served in our military services and also have had the experience of possibly being traumatized as a result of their service, having been subjected to types of injury in that service that is other than physical injury. Some leave with mental health issues, some will leave with homelessness as well as substance abuse disorders in order to be able to try to reintegrate themselves into the society. Coming back from the military, often our veterans find it difficult to reintegrate. They often find themselves experience homelessness at a higher rate as well. We're going to help our veterans to deal with those issues, to recover and to heal and be able to live a fulfilling life after they leave the program. And they have found their way into our criminal justice system as a result of having that experience in the military, which has magnified some of these disorders and situations. Dependency drug court is where we're speaking about juvenile dependency, as I spoke to you about. And so this drug court is going to focus on dealing with parents whose children have been removed from their care or custody and placed in out-of-home placement due to abuse, abandonment, or neglect. And the reason that they are no longer properly caring for their children is because they have a substance use disorder. If you are familiar with dependency, or if you're not, typically in these cases, after the child has been removed, the goal is reunification, to have the child go back once the parent has been able to rectify those situations that led to the removal. And in many cases, a lot of cases, drugs, it touches the family. It may not be the leading cause, but often even when there are other leading causes, you can find that drug or substance use disorder is present. So it is really something that is a big issue for our families and our parents. And Dependency Drug Court is one of those primary programs that they can participate in to help them to, one, get involved in drug treatment, be able to be successful, and then be able to regain custody of their child or children. Early Childhood Court is another program where we have in juvenile dependency where the child has been removed. However, Early Childhood Court, which we lovingly call baby court, it is a court in which we're dealing with cases where the children are between the ages of 0 and 5. And so we are taking families with those little bitty precious babies, and I always order that children should come to court. Because I want to see all those pretty little babies running around my courtroom. And so I'm one of the few courts that have children that are actually in the courtroom, in the wells. I'm down, I'm holding them, I'm picking them up, I'm interacting with them. But the main intervention that we have with baby court is that we're offering child-parent psychotherapy, because we understand that bonding and attachment between the parent and the child is significant. And we've also learned that if a mother or a father has a substance use disorder, or if they have mental illness or trauma, they're less likely to have a healthy bond and attachment with their parent, with their child. They most likely have been caught up in their serious mental illness or substance use disorder, where they really don't pay much attention to their child. Their children aren't thriving, they're not getting much attention, they're not getting much nurturing. And part of that is because their mother and their father are sick from their own disorder and aren't properly able to parent them. Child-parent psychotherapy is a therapy that is specialized. You have to be certified in order to offer that. It includes therapy between the parent and the child, right? And people say, how do you have a 2-year-old in therapy? Well, you can. And there's a lot of therapy that can be done, including play therapy, but also helping the mother to understand the cues of the child's trauma, the cues of the child's stress. And the goal is to break the generational cycle that's going to happen. If a mother is traumatized or suffering from that type of experience, then most likely what's going to happen is that child's going to grow up and do the same things. If we're able to break that chain, break that cycle, then we're more likely to have much more successful adults as well as parents in the future. All of these courts deal with our multidisciplinary team, and they're doing it on the basis of having non-adversarial proceedings. I don't know if it's me. There we go. All right. So how does a case get to problem-solving courts? I'm going to tell you all about that unless you have some questions for me right now. No. All right. We good? Everybody learning something? Good. All right. Now I'm doing it. Okay. So with that, how does a case get to problem-solving courts? Okay. First and foremost, we understand that somebody is arrested and then they come before a judge. All right. Let's just make it that simple. Okay. They have to come before a court. The main thing is that they're going to have an arraignment, which is at the first stage, in which they are advised of the charges that are filed against them. They're also inquired of as to whether they can hire their own attorney. If they cannot afford an attorney, one will be appointed to represent them. And then they'll be told the charges filed against them and what court they're going to, who their judge is, and when their next court date will be. All right, that's what all that happens pretty much at an arraignment, unless it's something that the attorneys have really gotten on top of and they're able to resolve cases at arraignment. That happens at a very lower rate. Most cases go a little further. because they haven't participated in the discovery phase, exchanging the evidence that the state has and what the defense might have as a defense as well. So at arraignment, the case managers for problem-solving courts are looking at these cases at that early stage. They're looking at the type of crime that the defendant has been charged with to see if it's an eligible case for the defendant possibly to come into our programs. The cases that are not allowed to come into our program are the higher felony offenses, second-degree felony, third-degree felony, first-degree felony and second-degree felony. Third-degree felony offenses may be eligible, and misdemeanor cases are eligible. The other cases that are not eligible to come into our court are forcible felony offenses. So most likely, just to make it simple, if it involves a crime of violence, if it involves a gun, if it involves someone hitting someone, committing a battery against someone, if it involves murder, if it involves rape, if it involves any of those forcible felony type offenses, without me going down the entire list, okay? Then those cases are not eligible to come into our programs, because our programs are intended for individuals who have committed lower level offenses as a result of their substance use, mental illness, or trauma, okay? So those are the cases that the case managers are going to look at, and they're going to determine whether or not they believe these cases are eligible to refer to our problem-solving courts. Anyone can refer a case to a problem-solving court. That means the defense attorney can refer, the state attorney, the case managers, the judge, anyone can refer for them to go through the process of determining whether they're eligible. Once that case is referred, then they will go through program screening with our case managers, as well as they will go to treatment to see if the treatment provider believes they're eligible for the case as well. Both the program and the treatment provider must agree that they are eligible. And there's some things that won't allow individuals to be eligible for our program. We'll talk about a few of those things later on. But if they are determined to be eligible, then we're going to set them on my docket. Understand we have several criminal divisions who get different cases assigned to their division. Hundreds and hundreds of cases assigned to their division. If they have someone who is eligible to come into our problem-solving court program, then that case is transferred to my division. So I'll take cases from all of those divisions that are eligible, and then they will come to my division, and then I will preside over that case. And so when I receive that case that is eligible, the defendant will sign a contract agreeing to comply with the requirements of our program. If they're on a post-plea track, they'll enter a plea, all right? The only sentence I'm going to give them is a probationary sentence of 3 years, it says, or 1 year if it's a misdemeanor, that says they must comply with our program. The other thing that will happen is that the case is specialized to me, and now I will be their judge from that point forward. Okay, so as I mentioned, the only thing that will keep them and make them ineligible to come to our program is if they have committed a forcible felony. And that's defined by statute, but I've given you kind of an idea of what that might be. Anything that involves violence is not admissible, with the exception of battery on a law enforcement officer. Now, most people would say, well, that's violent, isn't it? Well, battery is considered what most people consider to be assault. We call it battery when you unconsensual contact with someone, right? If you hit me, that's a battery. And so if a defendant, while being arrested, hits a law enforcement officer, that's a battery on a law enforcement officer. That sounds like a forcible felony, right? And it is. But law enforcement has agreed pursuant to our administrative order in conference with law enforcement here, have agreed that in those instances where we're dealing with individuals with these types of matters that led them to a criminal offense, if it's not something that led to some significant bodily injury or something that is quite egregious, then they will, in fact, agree to allow the defendant to come into the program and participate in our program. However, we do require that there is victim consent to come into the program. So if there is a victim in the case, the state does have to consent So in that instance, if it's a battery on a law enforcement officer, that officer can say, you know what, in this situation, I do not consent because of whatever may have occurred to lead to the charge itself. So they do still have that option. We have here where we score people to go to prison or not based on their criminal history. And so anybody who scores over 60 points on the criminal score sheet, getting a little more technical with you all, criminal score sheet is not eligible for our program. That's an instance in which they cannot come into the program even though they may meet other criteria. For mental health court, they must have a diagnosis of a mental health disorder by a psychiatrist or a mental health expert within 12 months of their admission into our program. So individuals may come and say, you know, 5 years ago I was diagnosed with schizophrenia. You have to be diagnosed with schizophrenia at this time, within 12 months. If you don't have that diagnosis, they cannot be accepted. In dependency drug court and early childhood court, the only cases in which we're dealing with parents who've had their children removed from their custody, the cases that are ineligible is if the reason for their removal is because sexual abuse of the child. They were not accepting those individuals into the program. That would not be appropriate for our type program, okay? So let's start talking about the criminal division in those courts that are, or programs that are there. I spoke to you about adult drug court. Again, they must have an acceptable felony offense or a misdemeanor offense. It's not only drug offenses. Guess what the other offense that we see all the time? Well, try guessing some of the other offenses we might see all the time. If you are having a drug issue or you have a drug addiction, what do you need? Money. How do you get your money? Stealing, petty theft, all right? A lot of times we see petty theft cases. If you have an alcohol problem, all right, and you drink a lot of alcohol, what often comes as a result of people drinking a lot of alcohol? DUI cases. We get a lot of DUI cases. So we get different types of cases. They're not only drug cases, but they're still lower level felony offenses or misdemeanor offenses, traffic offenses, DUI, reckless driving, driving without a license, all of those things that may not seem on its face to be something that's where we say you should go to drug court, but when we learn that the reason they're committing these offenses is because of their drug abuse, then they may be eligible for our program. And we also have the requirements is that they have to have victim approval in those instances. If you steal from Walmart, so you have a petty theft charge, we get to ask Walmart, do you disagree with them coming into our program or not? And they get to state whether they agree or not. Let me explain, however, a victim may not consent, but we are looking for them to, most likely, the state is going to try to explain the benefit of allowing that defendant to come into the program. And what we've learned is the benefit is that we're reducing the likelihood that that man's going to be at your Walmart next month stealing your stuff again. Okay? That's the benefit of it all. All right. So with that, our program requirements, again, you have more frequent status hearings as well as frequent and random drug testing is a part of it. That's going to help us out. Individual counseling, group counseling. I want to highlight some of the other activities that we offer. We have a community partner where they can do community service. We realize that idle minds are not good, and so we want to keep them busy. If they're not employed, then we definitely want them to either seek employment, enroll in school, or be active in doing some type of community service. We want to keep them busy so that they don't find the need, or because they're bored, let me go use drugs. So that's part of the programs as well. They're required to maintain weekly contact with their case manager. And we also have what are called peer support specialists. The peer support specialists are individuals who are going to assist them in helping them to maneuver through this system called the courthouse, called court cases, called being in the court system, and how to deal with treatment. How do you get where you need to go? What are the individuals going to provide, or what service they may help you with? The difference and the advantage of a peer support specialist, they are certified and they've had lived experience, which means they most likely have either been in an adult drug court before, or they've had some experience with a dependency drug court, or some type of rehabilitative or treatment process in their history. and they have recovered and they maintain abstinence, and they're actually able to be certified to be helpful and supportive of those who are currently having that experience. And they've been the secret sauce, to tell you the truth. I mean, isn't it always better to speak to someone who kind of knows what you've gone through, to relate to the experience? That's what peer support specialists do for our participants. So we have them as part of our team as well. They also get wraparound services, and we will adjust their requirements to what we believe to be the best thing. Yes, sir, a question?
Question, so when you ask for consent from the individual that the person is stolen from, what if it's mom or grandma? I mean, and they don't want them in the house, then what do you do in that situation?
If they don't want them in the house, they're not required to have them in the house. So we're dealing with adults, right? And so, because we don't have, we're not dealing with juvenile cases anymore. We used to have a juvenile dependency drug court program, but now we only are dealing with adults. So I'll just answer it in the adult context. If you're living with mom, you've stolen from mom, and mom says, I don't want you in this home anymore, and it's not your home, okay, then mom has the right to say you can't live in the home anymore. What the program or the case manager are going to do is try to assist that individual with finding some type of shelter, whether it's going to a local shelter or whether or not we can provide them a place in what's called sober living. And so there are some living programs or residential programs that offer sober living, individuals who are trying to live a sober life, and they can rent space to them, rent a room with them, or be in a part of a program in those locations as well. We all know that housing is limited for even the persons who aren't in our program, right, at this day and age. So it's not that easy to find housing, but we all know, we also are, as a team or as the program's team, they are going to work and do everything they can to find an alternative for that individual so that they don't live on the streets. Did I answer that?
Yes, follow-up question.
Sure.
So would that automatically trigger a restraining order against the person, or no?
When you, what would automatically trigger?
Like if they stole from, like basically they stole from mom. Mom says, I don't want them around me.
Okay.
So they get out of the house, you find them a place to stay, but then what if they still want to go back to mom's house? So would that be a restraining order too that would get put into place, or?
No, not necessarily, sir. If there is a case in which there's a pending criminal offense, then the mother can come to the court and ask the judge, would you please order that individual not to come to my home anymore, all right? Because now, for example, if he's in my program, and mother is asking, please, I'm asking you if you could just order him not to come to my home as part of his case. I have the authority to do that. That's not what's called a restraining order. But, you know, that's a legal term for us when you speak to judges. So it's not technically a restraining order, but I can make that a condition of his release or a condition of being a part of the program. That answer? Wonderful. Any other questions? I like questions, you all, now, so don't worry. Don't be afraid. Don't be ashamed. All right, there we go.
Can I go back a little bit?
Sure. Did you want me to go back on the slides?
No, I'll just tell you. Where it said you have to have a diagnosis of mental health 12 months past, what if they don't know? Or
12 months before.
I mean, yeah, within the last 12 months. What if they don't know that they have something?
Okay.
Like if you notice, Judge, and you think they have an issue, would you do something about it?
If they have come to ask to be accepted into our program, well,
And they exhibit symptoms, like could you
If
ask
it-
for
yes.
an eval?
I'm guessing the referral isn't made unless there's some indication or some question or curiosity that this person has a mental health issue, okay? So the lawyer is going to make a referral, for example, or state attorney is going to make a referral, or that defendant himself will say, I want to be in mental health court. All right, but if it's not, if that person is being referred, I'm guessing someone has a reasonable belief that that person has a mental health issue. If they have not had a diagnosis within the last 12 months, then what will be asked is that they go see a mental health specialist and get that diagnosis. And then once they've received that, then they'll continue with the process of being accepted.
I think I misunderstood, so that makes sense.
Okay. There are times I don't make sense, ma'am. I just, story of my life. Or did you? I'm sorry if I didn't make that clear. Yes, sir.
An attorney who suspects, I think maybe the point is, many people with mental health problems don't know it themselves. And when I've worked with the Office of the Public Defender, the attorney might suspect a mental health issue and then have somebody evaluated.
Yes.
Is that how they might get to you? Because the attorney recognized something, said, we've got the resources to get you evaluated, and if there's a diagnosis, hey, now we can refer to Judge Latimore?
Yes. Well, there are two instances, and as we know, and lawyers know, there are two instances in which someone might ask for an evaluation, and that's whether the defendant is competent to proceed to trial or to enter a plea. That might be different than saying you have a mental health diagnosis and therefore to be referred to mental health court. So mental health, as it relates to determining that an individual is incompetent to proceed to trial, has to do with their ability to understand the legal process and be able to assist their counsel, understand the charges and the consequences of the charges filed against them, okay? People who come into mental health court can be very much competent. They can enter plea. There's nothing that says that they're incompetent. What it is that they have a diagnosis, and because of the diagnosis and the symptoms of those diagnoses and how they manifest themselves may in fact lead them to criminal behavior, not necessarily not being able to understand how the legal process works. It also may lead them to use drugs because they want to self-medicate. And so often, as I mentioned, you may have someone who has a mental health issue but also has a substance use issue, and vice versa. You can have an individual who has a significant substance use disorder, and as a result of that, that will eventually lead to a mental health disorder because of their overall and excessive consumption of drugs and how that affects the brain. And so you can have those interact and be like co-congruent, co-occurring. All right, so we have those situations in which in either of those programs we're treating both, and they overlap, and there's a good percentage of individuals who have actually both of those situations going on. Did I answer your question, sir? Okay, no worries. Integrated team approach, here we are. This is the way it's going to look on an adult drug court program. We're going to have these individuals, as I indicated, this is what's considered to be the team. I'm the judge. I'm the one that's not going to have, on the ground contact with the defendant. That's against my ethical rules, and so I cannot be on the grounds, and there's certain information I can't have access to. And there's still confidentiality and HIPAA rules that are going to apply, but to the extent that the defendant has waived signed a release of information and allows these participants to communicate with themselves in this program, they're going to work together. We have the attorneys, as I indicated or mentioned. We also have that random drug test that's going on. We have community-based substance abuse treatment, a provider here in Orlando and as well in Osceola, but in Orange County we use Aspire, if you've heard of Aspire. We also have peer support specialists, the Department of Community Control and Probation for those who are placed on probation on the post-plea track, as well as individuals who can help with job or housing referrals. We actually work with Hope Florida, which is from the state of Florida, who can assist with having our participants work with Career Source or help to refer housing, sober living situations, etc. for our participants. But the key to this whole team and how it works is case management. And I always tell the participants, that's your lifeline. They are required to maintain regular contact with their case manager because that's the person who's going to tell them what they need to do. They're the person that they need to hear from, and the case manager needs to hear from them in order to determine how best to assist them. And they actually are the ones who's going to let them know how they're progressing. I meet with the team and what's called a staffing before court. Every time we have court, I meet with the team and we go over all of the participants, how they're doing in the program, how they're progressing, what their challenges are, and how we address some of the violations that may occur while they're in the program. That's adult drug court. So you can go a little quicker. Mental health court, pretty much the same thing in regards to that, but we have that mental health diagnosis within the first 12 months. They also are going to be required to attend those status hearings, and additionally, they may be subjected to random urinalysis tests. And you're saying, well, why are they doing random urinalysis tests? Well, as I mentioned, in a lot of instances, those who have mental health disorders also have substance use disorders. And therefore, if there's some indication that they're doing that, we will have them do random urinalysis tests so that if treatment is appropriate in that area, we can provide that to them as well. They are required to follow all the other similar rules that we indicated for adult drug court. Our team, as it relates to that program, is going to look pretty much the same. The difference is that our treatment provider is going to be mental health treatment, and that is Aspire as well. They do substance use treatment as well as mental health treatment. So Aspire is there. And understand, Aspire is not the only one. If for any reason there's a conflict or there's a reason our participant cannot go to Aspire or does not desire to go to Aspire, or if they already have their own mental health provider, say they've been treated for their mental health disorder for years, and they may already have their own psychiatrist who's prescribing their medication. They go see their own doctor, and they go see their own behavioral specialist. We're not going to make them leave that person who they have developed a relationship with and continue to work with to make them go to a certain provider, okay? If they are working well with that individual, we'll allow them to continue with them. They just will need to sign release of information so that the team can get the information that they need to show that they are compliant. We also are going to make assistance with having referrals from individuals who are on the team so that they are stable, they have stable housing, and they can receive the level of treatment that they need. Last but not least is our Veterans Treatment Court. And this is particularly for our adults who have been arrested with the eligible offenses, but they have served in the U.S. Armed Services, Allied Forces, or military contractors, and they can be eligible. Even if they were dishonorably discharged from the military, they can be eligible to come into our program as long as they meet all the other criteria. With this case, with this program, it's a little different. The statute provides that the state attorney is the only one who can approve an individual to come into the Veterans Treatment Court program, or for them to no longer be in the program when they're in diversion status. So the state attorney really has sole decision when it's related to Veterans Treatment Court in regards to the participants and whether they are approved to come into that program. And that is because the legislature believed that they wanted to make sure that it was the state that was making the decisions according to how the statute is written, and making sure that this program was made available to as many veterans as we possibly can offer it to. And so we welcome our veterans. We always start our court with doing the Pledge of Allegiance, and we make sure that we honor them and thank them for their service and the things that they have done in order to keep our country safe. And so again, they will go through the typical program requirements. What we need to understand, though, is basically the focus here may be substance use disorder, it may be mental health. We deal with a lot of trauma that the veterans have experienced. And often they find themselves homeless in their inability to reintegrate to our society. They've lost contact with family. They've lost contact with their friends. But the best thing is that they can actually better relate to individuals who have also been through the service. So if we can get them to work together with other members or former members of the military, that really does help them in order for them to be successful, because it really causes that cohesiveness to really gel. And so we find a lot of success with them. Many of our military servicemen or women have experienced sexual abuse while in the military. And often we find ourselves having to address that while they're receiving services in our program. All right, so this is what our team's going to look like with that integrated team approach. Same type of picture. However, the different persons at the table this time is that the Department of Veterans Affairs is there. We have a liaison. It's called the VJO, the Veterans Justice Officer, who is present at our staffings and present in court. And understand what's really different, I want to make sure, because I emphasize this team, you all, and how involved they are and why they are the secret sauce of the success of these programs. They're working together, they're wrapping themselves around them, they're at the staffings before I go into court, they're at court with me in court, and we're all working and speaking in regards to how that participant is doing and what we need to do. And so this is more like a communal activity or communal court, where it's not just two lawyers trying to argue their positions to a judge. We're here working as a team with that participant in the middle and saying, how can we make them successful? And one thing we can do with veterans is connect them to the VA so that they can get the services that they deserve by serving in the military. Oftentimes, veterans do not connect with them because they, one, don't know how. Initially, they think, I don't want to do it, it's going to be a waste of time, it's too much difficulty, it's too much red tape. We have someone at the table who can make it easy for them. She can actually get on the computer and schedule them an appointment or connect them with a provider. She'll be in court to resolve any questions, any issues that they may have. And so that's the benefit of these programs, is that we have everybody at the table and everyone present to share the information we need, work together, as well as to find solution quicker than later. Because you know, usually when you leave a room after having a meeting, everybody forgot what they were supposed to do. Oh, y'all had that experience too. That's good to hear. So really, it does happen. And so with that, this team is always working with each other, and they're always on top of what they need to do for these participants. The other thing that we have here is community-based treatment, as well as we have the other participants that you saw before. One thing I want to include here before we go on to the other dependency type problem-solving course, and this is going to be there as well. But I haven't mentioned, but I want to highlight family, friends, and community. They're at the table too. If we have parents who doesn't want their son kicked out, or even if she wants her son not to live in the house, but she still wants her son to get well, and she still wants her son to be successful in this program, and she welcomes him back when he graduates from the program, okay? She's at the table. She can be involved as long as he says you can release information to her, that's fine. And even if we can't release information to her, she could be a wealth of information to this program or to the case managers, everyone who's trying to help, because she's been living with him with drug disorder, drug abuse, or mental health issues. And so we welcome individuals who are families, friends, or anyone in the community who can actually help and assist with helping the individual be successful in our program. Non-compliance with the program, and this is for all our problem-solving courts in the criminal division, is that we will respond to their non-compliance, which means maybe they tested positive on your urinalysis test, or they didn't go take their urinalysis test when they're required to do so, or they failed to go to treatment, or they failed to come to court, or they're failing to do any other aspect of the program. Depending on what level they are at, what phase they are in the program, and how much they repeat that behavior and where they are in their recovery, because there are different phases of recovery. We're going to take all of that into account and determine how it is that we're going to respond to that failure to comply. And what they can receive, just to kind of sum it up from you, is a judicial warning from me, asking them and encouraging them to comply in the area that they need to comply with. And if they fail to do that, then they can face further therapeutic adjustments to their program, or they can face sanctions. And sanctions may include community service hours. It may include writing a letter to, in the instance of dependency, writing a letter to your child to say goodbye to your baby. That might be a sanction at some point. Also, a sanction may ultimately be time in jail. Now, we have learned through science and research that jail is not a good solution for individuals who are early in their recovery and individuals who have mental health disorders. And so with that, jail used to be one of the more used sanctions to encourage individuals to comply with the program, until the data and the research said, that doesn't help very much, depending on where they are in the program. If they are later in the program and they're in aftercare and they've done this program and they know about sobriety and they've maintained, abstained for a period of time, and they understand the consequence of making the decision to use again, then at that point they may face a jail sentence because they understand the process and they've gotten further along in their recovery. But early on, we expect individuals to test positive. You're in the right program. right? We expect them to test positive because they still have not learned behavior modification or to respond to crises and challenges in life without the use of calming themselves or self-medicating themselves. We expect them not to be compliant. You know, certain drugs, we have fentanyl out there that's just really dangerous, as well as methamphetamines or using meth. And we've learned that brain damage can significantly occur as a result of excessive drug use when it comes to certain drugs. And so even if they are in the program, meth users can be abstinent for 30 days, 60 days, and they still may miss a court date or miss going to do a treatment because their brain function still needs to be healed to the point where they can do those type of things that we take for granted. So we've learned all that through the research and learned that we have to appropriately address what they're doing. Therapeutic adjustment may mean that they have to go to more groups per week, or may have to do more individuals per week, or they may have to do intensive outpatient treatment as opposed to standard outpatient treatment. Or there may be a recommendation for them to go to residential treatment as opposed to going to intensive outpatient treatment. So we're upping the level of care or the level of treatment that they may need. That might be a response to their violation, depending on what that violation might be. And the others, as I mentioned to you, are sanctions. And so sanctions, again, may be that community service hours or placing them in jail, which we're going to try to avoid if we can. Last but not least is unsuccessful discharge. There are individuals who, unfortunately, they're not ready. They're not ready to recover. They tried to do what they can, but they're caught up in their substance use disorder, or they haven't been able to manage their mental health issues, and therefore they may leave. They may abscond. We don't see them. We can't find them. And I may issue a capias for them just so I can bring them back in to let them know that we no longer can help them because they're not complying. Let me tell you, though, when it comes to giving second and third and fourth chances, it happens in problem-solving courts because we understand that it's not going to necessarily happen the first time they get here. That there are going to be times when we see individuals, and I've experienced it, where they may leave us and we don't see them for weeks or months, and we find them and we say, do you want to do this program or not? They say, I really want to do the program. I really do want to do the program. Okay, we're going to continue to work with you. And we work with them and we work with them and we work with them, and then we can't find them. And we find them again and bring them in after picking them up on a capias. And we say, you really want to do this program or not? And they say, I really want to do this program. Please, give me a chance. And we continue to work with them, and they graduate. I've seen it myself. And it's amazing to see the transformation of individuals who go through this program. We've often showed them the mugshot of when they were arrested and a picture of them at graduation, and you'd be amazed that that's the same person. Not only how they look physically, but who they are and how they're responding. They have a job, they have stable housing, they're reunited with their family and their children. They're doing things that we want them to do, being productive, and they haven't committed new criminal law offenses. That's the key. That's what we're doing. Yes, sir.
Your Honor, the subject that you just mentioned, the people that sometimes disappear and come back, of all the people that you see come through these programs, what percentage would you say are people like that have to go through it 2 and 3 and 4 times?
Honestly, the ones who are in the program, that's the smaller percentage where they have to go through the program. Well, not just the program, but that we have to lose them and have them come back and lose them and have them come back, okay? That's really a small percentage. I have to say that that's less than 20%, okay? Recidivism rate here, even after they graduate, our recidivism rate is amazingly below 45%. That is low considering the overall recidivism rate for people who commit crimes, okay? So we are doing exceptionally well with our participants after they've had a chance to go through these programs. And that's because they get intensive treatment and attention. They also have supportive individuals, because usually people who come into the criminal justice system don't think you're on their side. They don't trust you. They don't think you're here to help them. They think you're here to put them in jail. They think you're setting them up. You're going to trip me up. You're not trying to help me. And when they realize that the program and the team is really on their side and really rooting for them and trying to do everything they can, they're amazed. and they thank them at graduation. And they talk about it as how far as not realizing that at first that you were on my side, but now saying you all are the most amazing people I've ever worked with. And I thank you for helping me to advance. Yes, ma'am.
That's great to hear. And what is the duration of the program? And is it
The duration, thank you, I meant to say that, but I'm talking so much. So with the duration of the program is that there's a minimum of 7 months for those who are in the misdemeanor program, and there's a minimum of 1 year for those who are in the felony program. All right, so they typically will have to stay in the program they will have to be in that program for them to be successful and finish the program. And that means that they've done everything they're supposed to do within that amount of time. Often, they don't quite get that. I mean, you have a few who actually meet that mark, and we have a few who go to the program. We call them honor students or honor graduates. Those are individuals who have no violations. They haven't been sanctioned. They haven't been judicially warned. They did everything they were supposed to do without that experience. But that is the time period in which they are expected to do the program. Good question. Yes, ma'am?
I'm awfully proud to be a member of this community and know that we are dealing in this humane way with people and giving them another chance. I'm proud to be a member of this community.
It makes me proud to be someone who does it too. Thank you. Thank you. And thank you so much for saying that, because again, I want to emphasize the fact that we recognize there are individuals out there who do not qualify for this program. This is not offered to everyone, okay? But the issue is that everyone who does a bad thing aren't bad people, right? And so the fact that they committed a crime doesn't mean that they're not worth us investing into to help them so that they no longer come back. I've always said out loud, if you're a substance abuse, if you're a drug addict and you go into prison, you're going to come out a drug addict, right? And you're going to continue to do what drug addicts do. But if we deal with the problem and we solve it, hence problem-solving courts, then it's less likely that you're going to do the same thing and end up back where you started. So that's the benefit of having this program. If they ultimately are not successful in the program and they get discharged unsuccessfully, then the case is going to return to the original trial division. Remember I told you that I'm getting the cases from those other trial divisions after they're referred. If they're successfully discharged, then they can be returned to the trial division if they're on a diversion track. Because remember, they have not pled, they haven't resolved the case. So the case is basically still what's called pre-adjudication, and therefore it goes back to the judge so they can decide how they want to resolve the case other than being in the program. If it is a post-plea case, they've already entered a plea. That case, if unsuccessfully discharged, will stay with me, and then I will handle the case as it relates to how they're sentenced, whether they plea or go to a trial, okay? And most likely at that point, we're going to get a plea to resolve it. Because even though they may not have been successful, state attorney is going to take into account what efforts they have made. And again, remember, we have cases that do not score prison, which is the 60 points I told you about, means they score prison. And therefore, we're not looking to sentence them to a prison sentence. I want to be fair and transparent with you all. We have persons who are in these programs who commit criminal offenses while they're in the program. They don't necessarily stop the behavior immediately either, right? So they may pick up another petty theft charge. They may pick up another DUI charge, etc. The team, being the state and the defense attorney, at that point will have to make a decision as to whether or not, and we want those cases to come in that qualify, all right? If they qualify, if they're lower level felony offenses, if they're another misdemeanor offense, we want to get all the cases. And we want them to be able to resolve all their cases if they're able to address the problem and get the treatment and be successful, so that they don't have one case resolved and they did everything, but then they still have other cases out there that goes the traditional route. We're going to take in all those new cases that they have, and the state and the defense are going to determine whether that's going to be a diversion track or whether that's going to be a post-plea track. Most likely, if they came in on a diversion track for the first case and they pick up a new law offense, then that may change things on how they continue in the program. But I would really, the reasoning, part of the reasoning as well is we don't want our participants to be in our program on one case where if they test positive for a drug test, that they get a sanction or some other therapeutic response, but in another case, they may get violated for probation. Because then they have this case where we're dealing with it therapeutically, and in the other case, they're going to get put in jail. And therefore, that's going to make it impossible for them to participate in our program. We don't have violations. We have, and I think I showed it on here where I mentioned it, we have the Department of Correction probation officers at the table as well. They're there. They're observing and monitoring everything that's being done, right? Short of a forcible felony or another crime that makes them ineligible, if they're testing positive or they're not going to treatment, etc., which may be a condition of their probation, even in my case, where they're on a post-plea track, they're not going to violate them. They're going to let us deal with them the way that we deal with them in our program, which means therapeutic adjustment or sanction, all right? Because having them go in and out of jail while they're trying to do treatment and try to do a program, it's not going to be helpful to them being successful. Now, if they ultimately don't do the program, then that's something that may lead them to some other type of resolution. Yes, ma'am.
Is this type of court nationwide, or are we lucky to have it here?
No, it's nationwide. In fact, it's a national, we have a national organization that's called All Rise. It's an association for drug court participants. And really, there are other organizations as well. We have Safe Baby Courts, where ECC Court came from. And so it is not just Florida. Although Florida has made it a true incentive for courts to have these type of programs, but it is nationwide. All right. So quickly, I'm going to go through this. As if we didn't have enough problem-solving courts, we thought we'd start another one, okay? And this is not under the typical problem-solving court umbrella. However, we best believe that should belong, or that it belongs in problem-solving court division because of the nature of how these are. As I spoke earlier when it was mentioned, there are times when a defendant is found not competent or incompetent to proceed to trial or enter a plea. And that means that that individual has been evaluated by an expert who usually is either a psychiatrist, a psychologist, a medical doctor who is a mental health specialist, okay? And also we can have the Agency for Persons with Disability evaluate individuals who may have intellectual disabilities. We also have neurocognitive experts who will diagnose them for neurocognitive disorders, for example, having dementia and traumatic brain injury. And so in those instances, however, I bring that up to you to say when a defendant is found incompetent to proceed, it mostly means that they have a mental health diagnosis, they cannot understand the process of how to maneuver through the court system and handle their court case before the judge. And therefore, that case is kept in pause until that individual is placed on treatment, medication, mental health treatment. They get to the place where their mental health is in order, and they're also required or can be required to do competency restoration so they can understand and be trained to learn what the court process is about. While that is happening, nothing happens to resolve that case. It doesn't go to trial. The judge can't take a plea. They have to wait until that individual is restored or the time frame runs in which the case can be dismissed with prejudice so that the defense the state no longer prosecutes until competency is restored or they believe it to be. So with that, competency court was designed, whereas in all those cases, we're coming on over to competency court in my division. And what we're going to do is we're going to take the team approach for those individuals as well. What used to happen is that these cases where the judge would tell the defendant, okay, you need to go to competency restoration training and you need to take your mental health, take your treatment, mental health medication and treatment and follow that. And then come back and see me in 6 months. How well do you think they did? if you really think about it, an individual with mental health issues and needing to get services are not likely to make their appointments, follow through if they really don't appreciate the illness that they're suffering from. Sometimes they don't like the medication, but no one's really watching. No one's really kind of supervising, helping, or supporting them and assisting them to do what they need to do. I often don't know what competency restoration is or how to get there or what I need to do. So we developed this competency court basically to help them do that. We take cases in which people are diagnosed with a mental illness that determines they're incompetent to proceed, and they're placed on conditional release, which means they're going to be released from jail on the condition that they comply with certain conditions, which include following through with their mental health treatment and doing competency restoration. And so what better group of people to have a team like the team approach that comes in problem-solving courts. So we're handling cases the same way. We also take cases where individuals are found not guilty by reason of insanity. Those are individuals who've actually gone to trial, where the evidence has been presented to a judge as a trial, and they were determined to not have a full understanding of the consequences of their behavior, just to kind of wrap that up because of their mental illness. All right, they couldn't appreciate that. And so due to their mental disease, they committed those offenses, but they were found not guilty by reason of insanity. They still have conditional release orders, which means you have to follow through with your treatment when we let you out. And this is the best way for us to monitor and supervise them, by having them come to competency court with a team that's going to oversee and make sure that they're following through. And so we have them come to court before me as well. So I'm going to go through this a little quick because I'm getting close on time, and I do want to take a chance. Court process is pretty much the same. We're going to transfer them over once we know that they're eligible for competency court. The defendant has been diagnosed with a mental illness, an intellectual disability, or a neurocognitive disorder, or found not guilty by reason of insanity. They're placed on conditional release, then they can be transferred to competency court, and I will set status hearing to supervise how they're doing in the community and complying with the conditions of their release. Going to have a team approach. The difference here is that we're going to have individuals who are providing them with mental health treatment, Aspire again, or any other treating physician that they've already have established a relationship with, as well as we're going to have the Agency for Persons with Disabilities to work with those individuals who have intellectual disabilities or autism as a result. And that's the reason why they cannot understand that process. And they're going to be providing competency restoration services, either through Aspire or through agency, depending on the diagnosis. Competency court does not accept individuals who are not placed on conditional release, who have been committed to the state hospital. There are instances where their mental illness is so advanced and they are at a state that's so critical that they need to be sent to the state hospital and with the Department of Children and Families. If they are in the state hospital, they do not come to my court until they have been released on conditional release. If a defendant is found competent to proceed while they're in my court, that is when I send them back to the trial division so that they can resolve their case. Dependency court, I'm moving on a little fast for you. I told you I want to talk to you about the ones that are in the dependency division, and that's when children are removed from the custody of their parents. And so when that happens, we have dependency drug court. Same thing, same drug court, same type of program, random urinalysis, test, treatment, come to court on a regular basis. They have incentives and sanction. And what we're doing is we're attempting to try to get them reunified with their children. So we're providing them those services in order to assist with that. They also have situations in which they can be required to comply with a sanction or an adjustment, and they have that same team available for them. And this is how the team would look. The difference is that the Department of Children and Families, or the community-based care agency that's offering them a case plan and the other services that they need to get in place for reunification, they're at the table, as well as we have all the other regular individuals at the table. And the guardian ad litem, who represents the best interests of the children, are at the table as well. Last but not least, early childhood court program, and that is the one I mentioned to you where we're providing child-parent psychotherapy to the parents and the children, and therefore they're going to address, the trauma that may have been experienced not only by the child through the abuse that they've had, but also by the parent. Usually, parents who have been traumatized will traumatize their children. So they need to go back. We don't want to send a healthy baby back to a sick parent. Therefore, we're going to have them receive some treatment through child-parent psychotherapy as well. And this one is, we actually have these on a monthly status. They have what's called family team meetings before, as opposed to, I don't have staffings in this case, these problem-solving courts. And they have what are called family team meetings, where they meet with my program coordinator over the program, and everyone comes and they speak about what's going on in the case to try to offer solutions, as opposed to bringing it to the judge and saying, hey, you rule. You order this, you order that. No, it's a team. You all try to work it out. See what you can do to work it out, because we want families to learn how to work with each other. And we even want families, the parents, to learn how to work with those individuals, whether it's a relative or a foster care parent, a friend, anybody, who took care of their children or child while they were removed from their custody. That's going to become auntie, isn't it? Right? That's going to become TT, because that's the person who's raising your child. Remember, these are children between the ages of 0 and 5. And they're taking care of these children and creating a real bond. And so, parent, when you recover or reunify, who else do you want, if you need a break, to send your children to? The person who raised them while they were out of your care, who they develop a relationship with. So we want them to learn how to co-parent with those individuals as well. And so that's what their team is going to look like. The only difference really is that they have the child-parent psychotherapist there, as opposed to having the other type of provider. So the benefits, again, as I mentioned to you, we reduce recidivism. Our graduates rates, I was high, wasn't I? Our graduate rates of recidivism is 12 to 17%. We reduce the symptoms that the participants have, and that means that they're less likely to have judicial involvement. They're more likely to follow through with their treatment. They're going to change. They're going to become changed individuals. They're not going to live the same life. We can always talk about people, places, and things. Remember, people, places, and things. Change the people you used to hang around. Stop doing the things you used to do. Don't go to the places you used to frequent. All right? And they actually will adopt that and become different individuals and become productive individuals in our society. They understand drug abuse, and they understand how it affects their lives. They understand mental illness, and that they need to monitor it and be able to manage it. And we also help to reintegrate them into our society, and I'm sure you will welcome back someone who is healed and whole, and we've addressed their problem as to someone we just put in jail for a few days or months, and now they're back doing the same thing. So that's our problem-solving course, you all. All right, any questions?
Judge Latimore,
Yes,
it
ma'am.
sounds to me like you have to be in court all the time with those bi-weekly and the monthly status meetings and your teams. They also have to be. It's a huge amount of work. How do you do it?
Bob's like crossing his fingers. So I do it, it still is within the regular work day of the week, correct? It's a lot of work, and it's even work outside of the courtroom while I'm outside of the courtroom and often preparing for the next court, whichever they might be, or traveling, etc. The team is working with them. It is a lot of work, but it's work that you love to do, and the work that we welcome, because it's work that's going to change the lives of individuals who come before us. And I think everyone who's on this team, you can't be a part of a problem-solving court or a problem-solving court team unless you have the passion to do the work. And when you have the passion to do the work, time flies when you're having fun, right?
That
Yes, ma'am.
segues into my question, which is, do you have any limitations on how many of these cases you can take? Does every case that's eligible get to be a part of the program?
So it can be that it can be challenging when the numbers go up. So the numbers, kind of fluctuate. And that's dependent on different factors in regards to whether we're having the attorneys in those trial divisions really understand how to make those referrals, when to make those referrals. whether or not we have sufficient time on our docket. I can tell you, we're never going to turn someone away because we say we don't have time on our docket. What we're going to do is we're going to take short lunch breaks. All right, so I typically start my staffings for my competency court. I will often start those at 1 o'clock, where usually we start them at 1:30. We've moved them up to 1 o'clock so that we can get into court on time and make sure we're doing what we need to do. We'll make those adjustments. Judge Reginald Whitehead is actually the judge who was assigned to start this division. All these different courts originally were assigned to different judges handling them. But it was through our Chief Judge Fred Lawton who asked that we put them under one division. He appointed or assigned Judge Reginald Whitehead to be the judge to become the first problem-solving court judge. And when he was in adult drug court, and we have two dockets, actually. We have an adult drug court for non-opioid and a drug court for opioid users, because treatment for them are different, okay? But at the time then when Judge Whitehead was here, I believe his ADC docket had 100 and some people on it. I don't have that at this time. But I would love it if I did have it at this time. I would find the time for it. The thing about it is that it fluctuates, and we'll adjust. We absolutely will adjust, and we'll ask the legislature to give us some more full-time employee spots so we can pay people to come on in and help us with that. Yeah. Any other questions? Well, thank you all. Oh, one more? You want to hold? We got one more minute.
I had a few. How often do they come back and say, hey, thank you, and do you interact with them in the future? I mean, after they've been through that?
Yes, absolutely. They come back. It is not as much as we'd like them to, of course. Some will come back, and mainly they will keep in touch with the team. They will be able to call the office or speak to their former case manager, or maybe they want some assistance. But I can tell you, I've actually done a podcast with one of our veteran graduates. I've also done a TV interview with one of our graduates. And so when they come back and they tell us how they're doing, we want to highlight it. We want to let the community know about it. And so they will do that on occasion. I don't have a number, though, but they will on occasion.
Okay. And then could there be such a wraparound service for juvenile sex offenders and their families? You know, like there's like Devereaux, but like what you're going through here, but apply the same to them, because a lot of the juvenile sex offenders have been, been abused.
Victims themselves.
Mm-hmm, been victims themselves. So having them on the registry doesn't really be as fruitful as it could be, but if they had a similar, like a mirror, a parallel type of thing, that would be really cool.
Hey, I think if you asked me, and if I was the king for a day, I would say all courts pretty much should have a problem-solving court component to it, because it is really, you're going to get a different response from individuals in our court system if they have a team and there's an integrated team, non-adversarial approach to try to help them really kind of digest what it is the court is saying for them to do. So when you place someone on probation, generally you say you're on your probation, you need to do this, 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 and this. But we leave them out there to do it on their own, where they don't have a team to help and support and kind of guide them through how they can complete those things. I think that there are several different areas in which problem-solving court approach would be beneficial.
That would be cool. And then also, how does one get involved with like peer support counseling or peer support?
There's a certification program, and I believe it's offered by the state of Florida. But if you'd like to know more about that, you can always call our problem-solving court office, and our number is on the website. I don't know it by heart, but the office is also on the first floor of this building.
Okay, and the other one is there's a nutritional science to this, because I'm finding out a ton about like whole food cafeterias. Now I'm finding that helping the nursing homes, the public school cafeterias. I used to be a lunch lady too, but I thought, boy, the families could really benefit from that, to learn how to, provide whole foods on a budget to their families. And I raised a bunch of kids too. But
I think it's good if you contact the coordinator of our program. If you suggest that to him and see how it is, it might be able to fit. It may fit more at dependency, because we have parents over there. trying to learn how to take care of their kids and be, make healthy homes for their children. And so that might be something that fits there too. We'd have to see, I think it's something that you'd have to discuss with the coordinator, because typically those who are on our team is something that we really is under the design of problem-solving courts. Okay, thank you for your questions though. Thank you all. Thank you, Judge Egan, I appreciate your time.
And thank you, Judge Latimore, and thank you all very much for being here. I just real quick, I'm a huge fan of problem-solving court and of Judge Latimore, but in the contrast between what someone like I might do in a felony criminal division and what she does is dramatic. If we truly want to help people, these programs are extremely beneficial. The statutory reason, though, for criminal justice and with adults, though, is to punish, not to rehabilitate. And that's sort of the friction between the two. So we try to get as many folks who qualify to Judge Latimore as we can. Think about it. If I put somebody on probation, even for a nonviolent offense, okay, 12 months worth of probation, and they don't qualify to see Judge Latimore, okay? Okay, you're going to go get a substance abuse evaluation, comply with treatment. You're going to get a mental health evaluation and comply with treatment. You need to take an impulse control class, okay? You need to take a life skills class. You need to get a job or make your best efforts to get a job. You're going to be randomly drug tested. Don't use drugs that are not prescribed to you, and you need to get all these things started within the next 30 to 60 days, okay? And if you test positive for cocaine in 3 months, you're going to be violated, and you're going to sit in jail, probably with no bond, until you get to see the judge to figure out what to do. So if we're really trying to help people, that's probably the way to go. And one other thing, though, is for any of us who know anything or know anybody who's been in treatment been in recovery for mental illness or substance abuse, it's not linear. You don't recover like this, okay? The traditional criminal justice system, if you don't recover like this, there's going to be consequences and sanctions, okay? But recovery goes kind of like this, doesn't it? And that's why this approach, to have people in the courtroom twice a month or even monthly, the team to help. I tried to make an appointment, but I didn't. My best friend died, and I relapsed. The judge in criminal court, like me sometimes, I got 500 to 700 cases. We just don't have time to get to the bottom of what's going on here. So I commend you, Judge Latimore. It's such a fantastic program. We went a little late today, I'm sorry. But next week, 6 o'clock, Judge Diana Tennis will talk about divorce court. So thank you all so much for being here, and we do hope to see you next week, okay?